Welcome back to Canadian Justice, where we're talking about the recent hearing at the Federal Court of Appeal in the legal challenge to Justin Trudeau's invocation of the Emergencies Act. Now, Joanna, one of the standards to invoke the Emergencies Act is that there needs to be a threat to the security of Canada, and this needs to involve serious violence. And the term serious violence is a term that's known to law. It doesn't just have any meaning. It just doesn't mean whatever the government says. So the thing that was interesting about this hearing is that they seem to be claiming, the government seems to be claiming that it, serious violence includes harm to Canada's economy. Maybe you can help me understand what that argument is about and maybe some of the problems with it.
Yeah, so this argument was particularly wielded by then Deputy Prime Minister Chrystia Freeland, who argued that economic security is part of national security and threats to Canada's supply chains, for example, constitute threats to national security. She really harped on this at the Public Order Emergency Commission. But it has been noted throughout the hearings and, in fact, accepted by Justice Mosley in the lower court decision that serious violence indeed means violence to persons or damage, like physical damage to property, not mere, shutdowns of the Rideau Center. And that's consistent through the Emergencies Act, the debates, and the CSIS Act. But what was interesting, as you mentioned, is that the government's lawyers on appeal very clearly tried to revive this already rejected argument and suggested that parking a truck on Parliament Hill could constitute a threat of serious violence on the order of terrorism. So they haven't let this go yet.
Really, some really strange arguments where the Crown's or the lawyer for the Attorney General seemed to suggest that running a big rig truck into a border building was the same level of threat as parking a truck in front of that same building. And I would just suggest that destroying a building is more serious than parking in front of a building. It's a sort of bizarre argument. Now, one of the other thresholds to invoke the act, Sujit, is that there needs to be a national emergency. And the lower court held that there wasn't one. So we know that of the different premiers of the provinces, 7 out of the 10 did not want the Emergencies Act invoked to apply to their province. So what does that tell us about whether or not there was actually a situation that applied nationwide?
Well, there probably wasn't. And I think, one of the most powerful um, points that was made by the government of Alberta in the case was that, Premier Kenny had gone on the record saying that we didn't want the act invoked. The RCMP had been able to resolve coups where there was, to be candid, an arms cache discovered and explosives, and it was a serious situation that was prevented by the RCMP using the criminal code. And he said we don't want the act invoked. And I think what was powerful in the hearing was that the government of Alberta said that we had a right to have Premier Kenny's views reckoned with and grappled with
Hmm.
by the Prime Minister, and they weren't. And the fact that 7 out of the 10 premiers said they didn't want the act should have led the government to then maybe, if they had to, invoke the act in those provinces which didn't object. And our view was that the only place plausibly to invoke it would have been Ontario, and even there it wasn't necessary.
Joanna, the Emergencies Act has been characterized as a tool of last resort because one of the thresholds for using it is that there is a national emergency that can't be dealt with under any other law of Canada. And we've argued at the CCF that there were various criminal law powers, that law enforcement tools could have dealt with this situation. And in fact, we heard from CSIS that there was no threat to the security of Canada, from the premiers that existing tools were sufficient, as well as from law enforcement, including the RCMP. So, what does that tell us about whether or not existing tools had actually been exhausted?
Well, I think the proof is in the pudding. So when you talked about, Sujit mentioned the incident at Coots, which was indeed concerning. That was cleared using ordinary policing techniques. There was, of course, The blockade of the Ambassador Bridge, which is a huge trade artery, also was cleared using, a show of police force and ordinary policing techniques. And so the government has the obligation under Section 58 of the Emergencies Act to explain why it is the last resort. And in this case, its explanation just stated that this cannot be dealt with under the laws of Canada, but that really glossed over the underlying reality. And in fact, how they cleared the protest in Ottawa, which was not using extraordinary powers.
We've got to go to break, but we'll be right back.